Okay, I'm going to jump right into this. This is about estate planning and powers of attorney. So, a lot of people I talk to, and the reason I'm recording this video is because people always tell me, well, estate planning only matters if I pass away or when I pass away. And I'm really not concerned about that today, or let them fight it out when I pass away. I don't care, I'm dead. That's not true. One of the most important tools or pieces of estate planning is powers of attorney, both financial and legal, and healthcare powers of attorney. So, what are powers of attorney? Powers of attorney allow you to choose who gets to make decisions on your behalf if you cannot. Financial decisions, legal decisions, and healthcare decisions. So, let's talk about what are powers of attorney and why should your financial advisor be asking you for one? You would be worried if your financial professional that you're working with doesn't ask for one, and I'll tell you why. It will sort of make sense after I define this, okay? So a power of attorney is vital because it allows you to decide, is it your spouse? Is it a sibling? Is it a child that you trust to make legal and financial decisions on your behalf if you become incapacitated, illness, accidents, or you're just not able to make a decision for yourself for whatever reason? I had a client who had a prolonged illness, and I had to work with their power of attorney to be able to make financial decisions during that period of time when they literally couldn't act on their own behalf. There's many circumstances or reasons. So for me, my husband and I are each other's powers of attorney. I couldn't be there to sign certain legal documents several years ago. He was able to do that on my behalf because he had a correctly executed power of attorney and could act on my behalf for legal and financial matters. I'm still alive, but I couldn't be there to do it. So a power of attorney is how you safeguard your own interests while you're alive and avoid the need for a court to appoint a guardian. Court-appointed processes, especially orphans court or guardianship, can be expensive. It's definitely complex and it's very time-consuming. So if you want to choose who has control over your affairs when you can't do it for yourself, you need powers of attorney, and powers of attorney that are correctly written, okay? So a healthcare power of attorney allows you to designate an agent to make medical decisions for you if you can't communicate your own wishes at that time. And sometimes I see clients who haven't updated their powers of attorney, and there's not a lot I can do because that's the legal document that we have, and it says this is the person we have to talk to for a financial decision if the client's unavailable or incapacitated or unable to make a decision for themselves. I'm going to tell you a quick story because I think it's important and I think it has a lot of relevance, but it also hits home a little bit. About 10 years ago, I had a client in Pennsylvania and they decided they didn't need to do estate planning. They literally said the same thing everybody says to me. That's for when we pass away. We're not worried when we pass away. Everything's simple. I actually was very concerned that they wouldn't do their estate planning. So I had them sign a document saying that I made them very aware of why these things were needed. And about 2 years later, his wife became diagnosed with Alzheimer's. And today she's not mentally competent. Every time he wants to make a change on her accounts, he has to have something signed by the orphans court. So your question is, but that doesn't make sense. It's his spouse. Okay. But when does a spouse get control of your retirement accounts or investments that are in your name only, which are always retirement accounts? And retirement accounts are always in your name only. The spouse only gains control when you pass away, right? Because your spouse, hopefully, if your, knock on wood, designations of your beneficiaries are correct, is your beneficiary. But if you have Alzheimer's or dementia, or you've had a stroke, or you're in a coma, and you can't make a decision for yourself, have you passed away? No. So do they have control of your assets? No, because you're still living. They haven't become the owner because they're the beneficiary when you pass. Okay. So this client, every time he needs something, we have to go to the court, and it's messy, it's complicated, it's heartbreaking, and he really regrets it. And he literally said, my planning is very simple. I don't need this. Okay. The second point on powers of attorney is I've had several clients who their brother went to law school and practices corporate law, so he did all their estate planning. That might be adequate. I've never seen it work correctly. Every time someone says, I downloaded my state kit, or my employer did it because I worked at this company and they had free legal services, or I downloaded the Susie Orman kit and bought them off the internet. Powers of attorney are very specific to your situation, and they need to have teeth. They need to give you power. A lot of the ones that I've seen that are written by attorneys who don't practice estate planning every day, they do some other part of law, or the client who downloaded it or got free legal services from work, it often doesn't authorize the power of attorney to transfer ownership. It hasn't given them the power they need to create a trust, or protect kids or grandkids in the event of asset protection being needed. Many powers of attorney don't have asset protection clauses or allowances. They don't have gifting authority. I know a lot of what I'm saying doesn't make sense to everybody, but you have to understand that a power of attorney is a very important document, but it needs to have teeth. And another thing is outdated powers of attorney. So let's use Pennsylvania. In 2016, Pennsylvania enacted changes to the power of attorney wording to address deficiencies in 2014 legislation. And then they made another amendment, I think, at the end of 2016, beginning of 2017. In Florida, a major overhaul was done in 2011, but there were further amendments done in 2021 and 2022. Now, there's other steps that need to be taken when your first power of attorney passes away or something changes. And that's why legal documents also have to be updated. But hopefully what I've shared with you makes it clear why your advisor should be interested in having copies of your powers of attorney. They need to make sure that if someone needs to act on your behalf, or if they're concerned about you. I have a client that I was very concerned someone was taking financial advantage of them. You know, the guy that takes them to the grocery store every week started asking for money. And I only found that out because the client started asking me for a lot more money than they've ever asked me for in the last 7 or 8 years. Well, that client, if they didn't have a power of attorney on file that I could read and I could see and I could call, there wasn't much I could do. I need to be able to protect clients. And any good financial advisory firm should be asking for copies of your power of attorney. Okay, so hopefully this was helpful. If you have any questions, please just call the office. We do this every day. We're happy to help.